Hi, I'm Blair Edwards, Managing Barrister of Edwards Law. My vlog topic is employer claims against employees and ex-employees. Most publicised employment disputes involve ex-employees making claims against their former employer, primarily for unjustified dismissal. There are, however, many cases where employers have been successful with claims against former employees. Employers have rights as well to protect their businesses, property, reputation, confidential information, intellectual property and proprietary interest, which can include their client, employee and supplier base. The most common of employer claims involve post-employment restraints of trade. The Employment Relations Authority and the Employment Court will be willing to impose post-employment restraints of trade on ex-employees, provided all of the requirements of an enforceable restraint of trade are met, including adequacy of consideration, which is usually remuneration or an offer of employment, reasonableness of duration and geographical scope, and if there is a proprietary interest in any company-owned information to protect. Such restraints can prevent employees from working for their new employer for a period of time, competing against their former employer, or stop them from dealing with their customers and suppliers, or prevent them from soliciting customers or employees for their own benefit or the benefit of their new employer. Enforcement can involve the issuance of interim and permanent injunctions, along with orders for damages, penalties and costs. Employers also have remedies against employees or ex-employees who have breached other employment obligations, including breaches of the duty of fidelity, good faith, confidence, along with breaches of duty of care or a term of employment has been breached. This can include claims where an employee has been negligent in their duties, for example, crashing the company car. Ultimately, where an employee's conduct is in breach of their employment agreement, the breach has caused the employer loss and the consequences of the loss are reasonably foreseeable, the Employment Relations Authority or the Employment Court may award damages to the employer to compensate them for that loss. Our firm has also been involved in cases involving both search orders issued by the Employment Court, where it is alleged that a company's confidential information has been taken and can be undertaken at the homes of those employees or place of work of that ex-employee, along with summons issued by the Employment Relations Authority where both current and ex-employees' personal computers and personal cloud-based storage systems, including Gmail, can be forensically searched under the directions of the authority. This type of order can also be extended to the employee's new employer and or business, which makes it a very powerful order. In the case of most senior employees, it may be found that they owe a fiduciary duty to their employer. Ordinarily, directors owe a fiduciary to a company. However, some senior employees, by virtue of their roles, will undertake specific contractual obligations which give rise to fiduciary duties. A fiduciary duty which is more onerous than the duty of fidelity is an obligation to act with a higher degree of loyalty and not to let the employee's own interests and that of the employer conflict with one another. This obligation can extend past the end of the employment relationship if the employee takes advantage of a business opportunity of which he or she became aware while subject to fiduciary duties. So all is not lost for employers who suffer loss or foresee that they will suffer a loss as a consequence of an employee's actions. There is a suite of options available to employers, depending on the specific facts of each case. We have a great deal of experience in these types of cases, so we'll be happy to assist you if you have any concerns about your employees or ex-employees' actions.